Catherine Amir Farr.
And I'm Cal Raustiala.
And this is International Law Behind the Headlines, coming to you from
the American Society of International Law.
Welcome back, everyone, to another episode of International Law Behind the Headlines. I'm very happy to have as our guest on the podcast today, Michael Scharf. Michael is, I think, very well known to a lot of listeners of this podcast. He's former dean at Case Western Law School, current president of the American branch of the International Law Association, and the Baker Hostetler Professor of Law at Case Western, and really a knowledgeable international lawyer on many, many topics. So, Michael, welcome to the podcast.
Cal, it is a real pleasure to be on with you.
Great. Well, I'm happy to have you. Michael knows when we first talked about having him as a guest on the podcast, the original idea was to talk about some of the seizures of vessels in the Caribbean that had begun to happen in December. We're recording this on January 8th, on Thursday, January 8th. In the interim, of course, those seizures have continued, and we're going to talk about that, but so much more has happened. So, Michael, if it's okay with you, we may veer into some of the other very important, arresting, and disturbing international law topics that have come up in the last few
years. Now, the world has moved on, and I'm ready to move with it.
Okay, great. So let's start with ship seizures. The reason I thought that was a good topic for the podcast is, it's both, it's an important geopolitical issue, of course, and we'll talk about some of that. But the legalities around these seizures are pretty interesting. I know the Russians, for example, as we're recording, of course, the former Bella 1, now known as the Marinara, has been seized as well by U.S. and I guess UK forces working in tandem. And the Russians have complained and accused the U.S. of engaging in piracy. Of course, there's been other complaints, other critiques made. So I thought this was a good topic to begin with, to kind of get into what is the nature of these vessels, what can you do, and so forth. So let's start with the nature of these vessels. They're sometimes referred to as a shadow fleet, evading sanctions and the like. How would you characterize them? What does that mean? Can you give us some context for that?
Okay, well, to start out with, every vessel that's sailing on the high seas has to be registered somewhere. And if they have no registration, then they're a pirate vessel. If they're registered, what normally happens is if they are sailing with contraband or they're doing some other illegality, the country that wants to enforce the law has to contact the flag country, ask for permission to board, and then they can board and seize. If they're not flying any flag and they're a pirate vessel, you can stop them and check to find out if, in fact, they're flagged somewhere. And if they're not, you can seize them as a pirate vessel. Now, very importantly, under no circumstance can you just blow them up with airstrikes. That is not allowed under international law, and that is absolutely clear. What we don't know for sure with these vessels that are being seized is, are they flying the Venezuelan flag? Are they registered to Venezuela? Or are they flying a flag of convenience somewhere else? But in any event, the United States just can't say we are interdicting them without permission of the flag state.
You mentioned flags of convenience, and I think that's probably a pretty familiar concept, but it does seem like a sort of flaw in the UNCLOS framework that it's so easy to utilize these flags of convenience and often so difficult to then carry out some of the processes that you mentioned. Is that a fair assessment, and is this as big of a problem as it's generally portrayed to be?
Well, and you mentioned UNCLOS, that's the UN Law of the Sea Convention.
Thank you.
What's interesting about that is the United States has not ratified that, even though every president since it was negotiated has been in favor of ratification. The U.S. Senate is just afraid of this treaty as some kind of entangling alliance, giving away too much American sovereignty. We did ratify the old 1958 Convention on the High Seas, which does apply here. And we've also, from time to time, said that the 1982 Law of the Sea Treaty, which we haven't ratified, nonetheless constitutes customary international law, with the exception of its provisions on deep seabed mining. So that's the law that's out there. And the law, even back to the 58 Convention, was clear that countries had to have a flag. on their vessels. You just can't sail around without a flag, or you are a pirate vessel. But then they have a very narrow definition of piracy. A pirate vessel is actually one that attacks another vessel on the high seas for private ends and pecuniary gains. And so I'm not sure that any of these are covered by piracy. The idea that a country's vessels can get flags of convenience has been around forever. And there have been reflagging cases throughout history. The most famous one was when, during the first Gulf War, the United States reflagged Kuwaiti tankers so that we could say, oh, those are our tankers and we're going to give them protection. And so this isn't something that is a stranger to the United States.
Yeah, thank you for that clarification. And just to add on UNCLOS, I think, of course, another topic we have covered on this podcast, and I'm sure we'll go back to, is exactly that deep seabed issue, which you mentioned seems to be the primary. I mean, there's a kind of ideological set of reasons why the Senate's been so opposed to ratifying UNCLOS, but that is sort of at bottom what's driving it. But you're right that the U.S. view is that it does encompass, for most things, if not everything, customary international law. And so I think we can safely refer to those rules as governing this area and having applicability for these kind of seizures. So let's turn to the specifics. So first of all, I just want to come back to what you said about obviously blowing up ships in the way that the Trump administration has done. Of course, I completely agree. The legal rationales there have been, let's say, erratic and arguably maybe inconsistent with what we see right now being argued about the invasion that took place. To render Maduro into the Southern District of New York. So we can maybe get into that towards the end, but just to say there's a lot of moving parts here, and they intersect in unusual ways. So on the ship seizures, let's start with the most recent one. One of the claims, which I believe to be true, is that the ship along the way changed its flag, or claimed to, and painted a Russian flag on the side. And the Russians then said, yeah, it's ours. Is that valid? How do we interpret that set of facts?
Well, no. I mean, anybody who owns a small vessel and sails it off the coast of the United States knows you have to have registration. And you can't just paint a flag on your ship and say, I have my flag. There's a whole process of registration. And it's sort of like the fact that if you're establishing a company abroad, you have to go through the hoops to have it become a foreign subsidiary, and you have to pay taxes abroad. In the case of ships, you have to pay fees. The country whose flag you sail is required to make sure that you abide by all kinds of regulations, including safety and environmental regulations. So no, you can't just be sailing around and just paint a new flag on and say, I've got a new flag. That's not how it works.
That seems eminently reasonable. What if the putative flag state says, yeah, we agree, which seems to be the Russian position? Does that change anything? I imagine legally, no, but as a practical matter, or how do you see that shifting maybe the equities here?
I just think that you'd have to say in that circumstance that it's illegitimate. I don't think that under the law of the sea and the customary international law, that is a legitimate way to become a flagged vessel. And so that would be rejected in a court of law. Let me also say that there's a long history of what it means to be a flagged vessel. In ancient times, people thought that if you flew the flag of a country, that you were a floating part of its territory. And there's a famous ICJ or PCIJ case, the SS Lotus. And what happens is the French ship crashes into the Turkish Lotus, and the Turkish ship and the French ship end up in Turkish port, and the Turkish government wants to prosecute the French watch officer and says, look, you committed a crime that had an effect on our territory, because one ship to another are like floating territories. So back then that was sort of accepted, but the International Court of Justice pretty much rejected the floating territory concept in a case involving attacks by Iran on United States ships and U.S. self-defense against oil platforms about 30 years ago. And so you can't attack a ship without violating, the Geneva Conventions, the Law of the Sea Treaty, but it's not probably the case that if you attack a ship, it's the same as an attack on the territory of the other country, and that is triggering the UN Charter's prohibition on the use of force.
Great. That's a very important caveat. So to come back to the ship, so let's assume it's the flag that's been painted is meaningless. It's not really a Russian flag, really not really a Russian registered ship. Whatever Russia may say as a legal matter, it's a pirate vessel or a stateless vessel or something like that. Is it a pirate? Is that, I heard you say earlier, pirate vessel?
It's not a pirate vessel because the Law of the Sea Treaty, even back in '58, defines piracy in these very narrow terms. So it would be either a stateless vessel or just a vessel that has illegitimate change of registration.
Okay. So if that's the case, what can the US or UK in this instance do both with the ship and with its contents? Now, it appears that this ship actually wasn't carrying oil. There are rumors about what it is carrying. Maybe it's carrying nothing. But let's just assume there's something on board, some kind of cargo. And of course, the ship itself. What could the states that engage in the seizure do with that property?
All right. Well, if they could figure out which flag they were legitimately carrying before they painted the big Russian flag on their hull, they could contact that country and ask for permission to board, permission to seize. If they seize, what they normally would do is bring it back to port in the United States. And then the owners of the oil, as well as the owners of the vessel, would litigate to try to get the vessel and the contents back. And there are all kinds of cases going back hundreds of years on that issue. It's well-established law. So you would just have a lot of litigation over that.
And do the sanctions that are in place here alter that calculus in any way?
Well, when I was back at the U.S. State Department, I had a lot of experience with the sanctions regime that was imposed on Serbia. And what we were able to do with those sanctions were often we could prevent a Serbian or Montenegrin vessel from leaving U.S. port because we could freeze them. But we never could sell them, and we could never take the contents from them and sell those. And I think that's the same thing with the current sanctions regime. I don't think that's changed. So, you just detain them, and then ultimately they rust and they clog up the ports. It's not an ideal situation.
Yeah. So interesting. So this is a good segue maybe to some of the drug boats and the way that those have been dealt with. Under normal times, the U.S. Coast Guard or DEA or other naval actors might seize a drug boat, let's say in international waters in the Caribbean, board it, take the contraband, presumably destroy it, arrest the individuals, things of that nature. Similar story, are those ships usually unflagged, therefore unregistered, therefore seizable and boardable?
No, usually the drug ships are flagged, and the U.S. Coast Guard will make a quick call to the counterparts in the country where they're flagged and say, listen, we want to board this vessel and we want to seize the contents because we think they're carrying drugs. Sometimes the Coast Guard will fly over with a helicopter and will take a shot at the engine to dismantle it and prevent the drug ship from escaping. But never before has the Coast Guard or any U.S. authorities actually used lethal weapons to kill all the people in a ship that was suspected of smuggling drugs.
Agreed. And what about when, let's take those sort of semi-submersible quasi-subs that drug traffickers sometimes use. I'm guessing those are not flagged. When there's a non-flagged vessel, does anything really? I realize we're veering into an area you may not be expert in, so feel free to bat this back. But is there any difference there when you're dealing with a non-flagged non-registered vessel?
Well, of course, if it's non-flagged, non-registered, you don't have anywhere you can call to ask for permissions. So in that case, you board them and you ask them, are you flagged? Are you registered? And if not, well, right there, that's an infraction. That's a violation of the law to sea. Every ship has to be flagged. It's an infraction of U.S. and foreign law. And then while you're boarding, you happen to see all the drugs, you're like, well, now you're in real trouble because you're sailing around with contraband. Now, one of the problems is a lot of these drugs aren't heading for the United States. And so U.S. courts have sometimes had trouble exercising jurisdiction over people who are smuggling drugs not in our territory. And it's not clear that they're coming toward the United States. Maybe they're heading toward Europe. And so that's going to be just a whole nother complication with what do you do once you've brought the vessel and the drugs back? What will the U.S. courts allow you to do?
Because as a jurisdictional matter, their claim to jurisdiction over these vessels, they're not bringing a harm or causing an effect. To go back to the Lotus example that you used a little while ago, part of what makes
That's right. So in order to exercise objective territorial jurisdiction, you have to show that the drugs or the contraband were heading to the U.S. or were intended to be heading to the U.S., and that could be difficult to prove. And it's the same thing if your theory is some kind of national security theory. Ever since we started calling it the war on drugs, and of course, President Trump has now declared the importation of drugs into the U.S. as equivalent of a weapon of mass destruction. Now you can use, the national security, the protective jurisdiction of the U.S. courts, as well as the effects jurisdiction. But in either case, you have to show that it was coming into the U.S.
And how is that usually? Is that simply a matter of directionality or proximity to our waters, something like that? In which case it would seem like seizing something close to Venezuela, let's say, would be difficult because Venezuela is actually pretty far.
Yeah. So, you use circumstantial evidence. It can be everything from, are they on a steady course toward the United States? Do they have maps that have like little circles drawn and compass markings in them? Do they have co-conspirators in the United States? They often do. I mean, you don't just come up to the United States and drop your drugs or like sell them from the side of your boat. So if they're co-conspirators in the United States, that's a real link. So those are the kinds of circumstantial evidence you'd look at.
Okay, great. This is terrific. So I would love to pivot a little bit to the issue of blowing up the drug boats, because I know you have thoughts on that as well. You mentioned earlier that's contrary to international law in many ways. You also mentioned just now the administration's argument that this is legitimate, one, because it's a kind of armed conflict, or I guess they're a bit evasive on that point, but that fentanyl itself constitutes a weapon of mass destruction. Do you see any plausible argument there that it is, in fact, a weapon of mass destruction? As I understand it, the argument is, with such small quantities are so fatal that I guess it approaches a chemical weapon in its nature, something along those lines. It can be aerosolized. It has been aerosolized and used as a weapon. The Russians famously used it. So is there some credence that we can give to this argument, or is it completely a make-weight?
I don't think there's much to it. So, weapons of mass destruction starts out with nuclear weapons, and we know what happens when you use those. Then it expanded to dirty bombs, where you're using nuclear materials, but you're not actually setting off a nuclear reaction. Also, really horrible results. And then they went to chemical weapons, which there'd been a taboo on, and nobody really had been using them until Saddam Hussein in Iraq. And I think, though, when they're talking about chemical weapons, they're talking about massive use of chemical weapons like sarin gas or chlorine gas. And even though, you can take the fentanyl and weaponize it, it's not likely to have a massive kill ratio. And it would be really expensive compared to the other chemical weapons in order to mass produce it at that level and then just drop it as a bomb. So I think this is really an exaggeration. And if you go there, what else is going to be a weapon of mass destruction? Just about anything. And that sort of takes away the whole paradigm. Because the weapons of mass destruction are so scary and so dangerous, it almost allows the president to do whatever he wants to protect the U.S. people. And that wasn't designed for someone who's sending in, first it's going to be these drugs, and then it'll be opiates, and then it'll be marijuana. And it's just, a slippery slope, and it's not what it was supposed to be for.
Yeah, I mean, on the slippery slope point, it seems like there's any number of things which, if you scale them up, kill. French cheeses probably kill a certain number of Americans simply because of the saturated fat. You can imagine.
And you also have the dual use problem, because just about every one of those things, has a legal use and an illegal use. And, how do you prove which use it's coming in for?
Right. So, yeah, that argument seems to have no real limit. On the chemical weapon analogy, I agree with what you said. It does make me think of the Carol Ann Bond case before the Supreme Court many years ago, in which there was a woman attempted to be prosecuted for using a chemical weapon allegedly against a neighbor. And it went all the way up to the Supreme Court. And it was interesting because the court ends up, the case had many ramifications of interest to international lawyers, but the court essentially says, yeah, this isn't what we meant when we had the Chemical Weapons Implementation Act. But there, the focus was more on sort of the one-to-one scale, I think of it, that there's a single person trying to kill another person. And while that's terrible, that's not use of a chemical weapon. Here,
I don't even think the drugs are coming in with the intent to kill.
Exactly. There's no intent.
It's all about making money. And if it was killing everybody all the time, that would be a really bad marketing, ploy.
Yeah, exactly. I think the issue, obviously, it does kill a lot of people and unfortunately, huge numbers. But that doesn't appear to be the intent. It's not sensible as an intent. And so, again, this feels like a real make weight of an argument, and one that, again, has no real limits. Alcohol, there are many other items that are imported into the U.S. that are very deadly if used wrongly, or even if used properly, but at a certain scale. So it's hard to know where they would draw the line there.
Yeah.
So, okay, we only have a few minutes left, but I can't resist asking you a little bit about the abduction of Nicolas Maduro, since we're generally focused on the Caribbean and Venezuela in this podcast. A lot of opprobrium about this. Obviously, the Trump administration is trying to claim, at least not Trump himself maybe, but the other parts of the administration seem to want to call this a law enforcement action, where DOD was simply, the Defense Department was simply there to support the FBI. And this is a straightforward criminal matter, which is why he's currently, sitting in New York, ready to go to trial. Do you want to comment on that chain of argument and whether you think there's any validity, maybe going back to, the Panama precedent? How do you see this differing? So just weigh in on those questions in a few minutes.
Well, countries cannot do law enforcement in other countries without their cooperation and permission. That's also a violation of territorial integrity. When you use massive force, and in this case, this was as big a force as you can imagine.
Many people killed.
You can't just say, oh, this is just, law enforcement activity. And in Panama, our claim was we were protecting the Panama Canal, which was under attack. And at the time, we had a treaty obligation to do that. So we didn't even claim that we were just going in to arrest Manuel Noriega because there was an indictment for him. Nobody would have thought that that was legitimate at the time. And for us to now use that as the precedent and say, oh, we did it then, that's really... It doesn't pass the straight face test. Now, the problem, of course, is that a lot of countries have indictments of all kinds of leaders all over the place and former leaders. And is this, open season for them to start abducting? And we know that there is a taboo in international law about assassinating foreign leaders. But this may be, as they call chemical weapons the poor person's nuclear weapon. This may be the poor person's assassination. If the U.S. has established this as a legitimate precedent, then countries are just going to go around snatching people that are in leadership positions that they don't agree with all over the world. And I can tell you, Zelensky in Ukraine is going to sleep even worse at night, knowing that this precedent might be encouraging Russia.
Yeah, absolutely. I mean, we do have a track record of snatching people and rendering them in different ways. Now, leaders, duly elected or not, I guess that's a bit of a question mark here, raise a bunch of separate issues, just like we have a executive order against assassinations going back
right
administrations. But is there anything fundamentally different about what happened with Maduro versus, let's say, the many extraordinary renditions and other kidnappings going back, Alvarez Machine, going back to many examples from the 80s and 90s and early 21st century, other than the fact that he's a leader of a major sovereign state?
Yeah. Well, I was at the State Department during Alvarez Machine, and the State Department and Justice Department had a big disagreement about it. Abe Sofair, the legal advisor, testified before Congress. He said, look, this was not legal under international law. But then Barr, who was the attorney general then and then came back as attorney general years later, William Barr said, well, it doesn't matter if we violated international law because under our Kerr-Frisbee doctrine in the United States, it doesn't matter whether there's an illegal snatch as long as we treat you well once we get you to court. And the Supreme Court accepted that. And that has been the case in the U.S. courts about foreign snatches. It doesn't mean that they're legal internationally. Now, the ones we've done since then, and in fact, there was a NSC agreement between the agencies saying that from now on, the State Department had to be consulted because this is a real big problem for the United States when we're going around snatching people. The ones since then have all been high-level terrorists. And with respect to terrorists, there's an argument that they are a threat to the U.S. self-defense. And for that reason, we do have a self-defense rationale. I don't think that rationale worked in the case of Venezuela. First they tried to use it with the drug trafficking. We've already dismissed that. And now they've shifted to the law enforcement paradigm, which isn't going to work as well. So I do think that we're looking at a real new precedent here, and it's going to be condemned around the world, and there's going to be a lot of pushback. But if we keep doing it, it could really weaken the sanctity of international law and the rule of prohibiting the use of force against the territorial integrity of foreign countries.
Agreed. So final question. I know the Security Council had a meeting this week, obviously, about this incident. There's been, I would say, mixed reactions from both regional states, like, in Latin America, but also other states that haven't really criticized the U.S. particularly much. Certain states have, of course, criticized the U.S. along the lines you just described. How do you interpret the, let's say, muted response from other states? Is it because Maduro was so widely disliked? Is it fear of Trump and his well-known, retributive nature? How do you interpret it?
You just answered your own question. I think it's a combination of the two. When you attack a country whose leader is a human rights violator and is doing corrupt and horrible things, there's not a lot of support for that leader, even if there is support for the principle. And on the other hand, the rest of the world is becoming increasingly fearful of Trump and his retaliatory actions, not only what he does with tariffs, but if you're Greenland and Denmark right now, you're very nervous about what's going to happen in Greenland because he's got his sights set on that. With respect to Canada, the day that Canada recognized Palestine as a state, Trump put sanctions on Kim Prost, the Canadian ICC judge. And that was ostensibly because she sat in on the decision of the appeals chamber that opened the investigation on Afghanistan. But pretty much everybody I've talked to thought that there was a direct line when you connect the dots to Trump being angry at that action in Canada and saying, I won't stand for these things. I'm not a pushover and I will retaliate. And I think that's got the world on pins and needles. But even though the Security Council has not taken action, of course they wouldn't because the U.S. has a veto. There could be a resolution of the General Assembly. And there was one in the case of Panama. And I think we have to wait and see what happens. I wouldn't be surprised if there wasn't a resolution. And it could be expressing concern, condemnation. It could create an investigatory mechanism. There's all kinds of things the General Assembly might do.
Yeah, agreed completely. I think obviously if a veto is wielded, you can definitely expect that. But even if not, it's just also interesting how Russia and China they are reacting, already, but obviously they have their own interests in both maintaining the system, but perhaps using some of these rather large loopholes that Trump is now creating. Michael, thank you so much. This was a terrific conversation. We can go on for a very long time. I know we'll have you back. I really appreciate you coming on.
Cal, it's a pleasure, and enjoy the new year.
Great. Thank you.